Welcome everyone. Today we have Dr. Vijay Upadhyay with us. Sir is going to make a webinar on fundamental of intellectual property rights. Sir is PhD postdoctorate from Imperial College, London, UK. He's Deputy Director of Center of Research for Development and also Associate Professor, Parul Institute of Applied Science. Here, I request Sir to continue with the webinar.
Thank you, Dr. Madhavi Madam. First of all, I express my sincere thanks to all the organizers who have invited me to share my thoughts or my views on the IPR. So I'm presenting my screen. In between, you can interrupt me if I'm not audible or somewhere get stuck. So my slides are visible to you, madam? Hello?
Yes, sir.
Okay. So today we are starting. Today we are starting our discussion with the intellectual property rights. Before going to give the insights about what are the intellectual property rights, I need to first explain you about the Global Innovation Index. Then on the global mark or the world map, when we have to understand the power of innovation or the power of the country. So any power or the strength of the country, the scientific strength of the country is determined from the Global Innovation Index. And this Global Innovation Index is based on many factors. The number of institutions they are having, human capital and research, infrastructure, market sophistication, business sophistication, knowledge and technology outputs, creative outputs, and all these pillars or all these factors, they are contributing and they are giving the Global Innovation Index. What is the innovation? We will see in the next. The innovation, there is a difference between the innovation and the invention and the innovation. We will first understand what is the innovation. But we will come back to this one, but first to understand what is the Global Innovation Index. So all these factors, the country who is having this strong in all these factors will definitely lead or definitely hallmark the Global Innovation Index. So if you can see that the top 20 or the institutions or the countries who are ranking or the top rank on the Global Innovation Index, so you will find the Switzerland, Sweden, and also on the 14th stage, the China. 2 days before, I recently received one news on the WhatsApp that more than 2,000 of these patents, they are every day filed by the China, and you can understand why they are dominating today's era. And India's rank, if you can see, considerably, we are now at 48. This is up to the 2019. The latest is we are at the 48th stage. So in 2015, India rank was 81. Now then to 66, then 60, then 57, and in 2019 it was 52. And now we are quite satisfied that in 2020 we ranked to 48. So still there is a long way we have to go if we have to come within 20. So this is the Global Innovation Index on which the ranking is there, and all these big countries which you can find on the top, because they are putting more infrastructure, more money in investment into the innovations. So as far as the Asian countries are concerned, so as per the ranking of the India in 2018 and the 2020, so we are having, India is having third rank amongst the 29 lower middle income group economies, and we are almost ranked first among the 10 economies in the Central and the Southern Asia. But we should not limit ourselves to the Asian part or the middle income group economies. If we have to grow globally, then we have to come within 20. That should be the benchmark. So Global Innovation Index, now you understood. Now we have to understand that what is the first, before going to the intellectual property right, we need to understand that what is the invention and what is the innovation. Any primary scientific thought, any primary discovery, the primary form of any discovery is known as the invention, and the sophisticated stage or the modified stage or the lateral stage or the advanced stage of that invention, you can call it as a innovation. So like the Newton has first invented that the gravitational force. So it is the invention we can call it, because the first time that thought has come. So when any raw idea or the nascent idea is coming into the mind, and it is the take of any discovery, we can call it as an invention. But when as per the market need, as per the customer use, or as per the demand, when we are doing something adjustment into that or the modifications to that, that was called to be the innovation. You might have seen that key earlier type of discoveries, they are, when it comes in the original form, sometimes it was not user friendly, but as per the market requirement, as per the users, as per the customer satisfaction or whatever it may be, we can making the change. So that will be the innovation. So before going to the intellectual property right, we will understand with the examples what is the invention and the innovation. So invention, as I told you, it is the raw, the nascent form, the primary form of any discovery. It is nothing, it is like a calculator. We are using the calculator in the same form and there is no more advancement we have seen it. Seen we are using at the same format. The combining two or more products like the camera, computer, telephone, or the Mittika cooler, suppose. So many first invention, you might not be knowing the when fan is invented, it might be having the 6 pans, but later they have assumed that it should be 3 pan is sufficient. So in that way, as per the requirement or the sophistication or as per the modification, the changes has been observed. Now I will give you the example of that in very first during our PhD times in the 1990s, we used to use the 20 rupees, the floppy disk. So if you can understand in 1980s, the floppy disk 20 rupees, it is having 500 MB size. So you can call it as a floppy disk as an invention. Then it is converted to the modified form or the sophisticated form. New version came as a CDs. Now the pen drives are there. Now the memory sticks and other hard drives are there. So, and we don't know in the next time the more sophisticated form can be used. So the lateral forms, you can call it as an innovation. But the primary form of floppy disk is the invention. Audience, you are getting my point? Hello? If somebody is audible in between, you can say yes, so I can. Yes. Yeah. So sometimes the internet disconnected.
Yes, sir, it is audible to them.
Yeah, please. Thank you. So sometimes internet can be disrupted and it can happen that I may continue and that there can be a distraction or the link can be disturbed between us. Now the innovation. Now what is the innovation? Now invention was done. But is it as per the requirement of the customer or as the requirement of the problem? So innovation is based on the many factors, applying better solution to the problem. The solution to the problem can be invention, but the better solution, the developing new solution to the problem, changes that makes a positive difference. And the new ways of delivering that the existing service, now the telehealth, telepathy, most of the things which are calling. Almost the pathy or that the science is the same. But as per the requirement, we are doing the change. Now you can see that the classes we are taking on. Now we have changed to online classes, virtual classes, virtual lectures. Even this platform we are taking this webinar. Also tomorrow the new format can become. So this can be the innovation. So new things are coming which can joining the audience with the speaker or the orator. We can call it as an innovator. So thinking differently, innovation. So you cannot say that, okay, one invention was done. You cannot do it. The further improvisation is always taking place. And that's why in the science, we are telling that, suppose you can tell the coronavirus. The first coronavirus which came, the vaccine which came, you can call it as an invention. Now another mutant came, that UK mutant came, UK strain is coming, which is again giving that corona. So whatever the vaccine will be updated, that will be more innovative. So that vaccine, you can call it as a new version of the vaccine. So that is the innovation. So as long as the corona or the viruses, they are changing themselves, we are also updating ourselves in our vaccine form or in the diagnostic tool. So that is the innovation. You can understand that Thomas Edison, who was invented a bulb, it is a creation of the product or the introduction of the process for the first time. So Thomas Edison, he invented bulb. So the Thomas Edison was an inventor. But Steve Jobs, before Steve Jobs, there was a Microsoft window was there. But innovation happens when someone improves on or makes significant contribution to something that has already been invented. So before Steve Jobs, the Microsoft window was there, but he was done iPad, iPhone, and all this dramatic. And now also you can see that the Apple quality is so. Most of the industrialists still they are preferring the iPhone and all this. So you understand that key. Innovation is the quantum jump. Sometimes we call that this is the first generation, second generation, third generation, whatever. So generation means a quantum jump. We are using the PC earlier in our desktop. Now we are using the laptop. So you can call it as a laptop is the more innovation form of the invention. Okay. So in that way, this journey or this movement will going on. So as far as the science is concerned, we have to be more innovative mind. That's why people are calling nowadays that we should have the innovative mind. They are not telling us we should be inventive mind. Inventive is also good, but innovative, that you are bridging up the gap between the market and that the sustainability of that product. So innovative mind is the today's need. So now you can understand that these are traditional choices, the traditional approaches, and with these traditional approaches is going to the new versions and showing the practical applications of the inventions into the marketable products and the services. Okay, so invention means the outside, inside you can see that the what are the circuit layouts can be things, but as for the small mobiles is coming or the small devices coming, as for the small and that easy to move or the easy to carry or user friendly, so accordingly the layouts can be changed, and so we can call it as a innovation. But only the changing the shape of size is doesn't mean that innovation. With some technical utility, technical utility should always be the aspect of the innovation. Again, the Tim Berners-Lee invented the World Wide Web, internet. Okay, so internet is a common that everybody can search it. WW is a common platform. You can call it invention, because before this we were not knowing about the internet. But Mark Zuckerberg, he was developed this social site, that is the Facebook. Now WhatsApp also. Most of the people, or we are investing, or I don't know, we are wasting or we are utilizing our time on WhatsApp and Facebook. Most of the time, most of our productive time is going on that. We can use it on a healthy way, scientific way. So Facebook, you can call it as an innovation. So I hope till that point, the invention and the innovation difference you have understood. Now, intellectual property right. What is the intellectual property right? Property, I belongs to some property. I have some tangible property. Tangible property means vehicle, land, property, 1 BHK, 2 BHK, shops, the Galaxy malls, whatever. These can be called as the tangible assets because you can visualize it. Okay. But sometimes there are the intangible assets also. What are the intangible? Something in your mind. Something in your mind. The property, one property you purchase, the land you purchase, car you purchase, 4-wheeler, 2-wheeler, or all these assets you can purchase, tangible assets. But other property you cannot purchase, you are producing by your mind, by your scientific thought, by your creation. And there can be different forms of the intellectual property, right? I will come one by one. So property, you understand, tangible, which you can purchase and you can visualize. Intangible means which you can create, which can be your inventive mind. Why now here I'm using the inventive mind means first time that thought is coming into the mind, and according to that thought process, as per the commercial angle, you are making it to the innovative way. So in your mind, this property or this thought should be both inventive as well as innovative way. Now intellectual means it is coming from your brain, from your intellectual, from your knowledge, from your wisdom. It is coming. So that's why intellectual and the property. Now rights. What is the rights? I am giving you the right. The university given you the right to work 9 to 5 and take the lecture. The university given you the right to the student to come and appear for exam and on that courses and all this. Like that, the government has given the rights to me. You know, this is my intellectual right. This is my intellectual property. So nobody can take it. Just like that, you are going to outside shop and you are locking your home so that you can protect your belongings, you protect your wealth, you can protect your cash. Okay, you are locking your cabin, you are locking your almirah. Why? Because you want to keep it to yourself only. You don't want third party should use it, and if they use it with your consent only. So government is giving you the right that your property, which is your intellectual property, your intangible asset, should not be used without your consent. If I'm writing one poem and I'm exploring and I'm giving consent that, you know, nobody can read my poem or my book or my any software, anything or my technology, so that I'm giving the right. But government is giving me the right that I should decide whether I should give it to someone or not. So in that way, the intellectual property right, I told you whatever your scientific understanding, scientific creation, it can be also takes in the form of intangible property, intangible assets, and it is a right protected. Right protected means third party misuse, third party violation can be strictly avoided. And if somebody is doing so, if somebody is doing such type of infringement, he will be punished. Okay. It is the same like that, without your consent, nobody can enter your home, nobody can enter your office. So obviously, without your consent, without your permission, they cannot go forward. So as I told you, the tangible assets like the land, vehicle, equipments, inventory, but these are the intangible assets, not in a physical form. Sometimes you have some thoughts, you have some theory, you have some creation, goodwill, brand recognition. So there are the various types that we will see. It can be literary also, it can be artistic work, it is a scientific work, design work, symbol, names, images, everybody that can be used for the commerce. Commerce means from wherever the revenue can comes. So that is the intellectual property. So I hope that intellectual property, that word is clear to you. So before now, I will tell you the what are the intellectual property. There are the how many types. So before going that intellectual property, I want to tell you that the Nuns rule. This is covered in not. Okay, the Nuns rule. I want to tell you that now what are the intellectual property rights? The intellectual property rights, I can tell you, the first is the novelty. Whatever you are inventing, whatever you are presenting inside the scientific fraternity or to the world, it should have some novelty. Novelty means some uniqueness. Nobody has thought before. So Nuns rule, Nuns. So I can say my product or my whatever I'm bringing to the society, it is a intellectual property right. It is a intellectual property. It is IPR. So if that IPR, it should follow the Nuns rule. First is the novelty. Novelty means that it should be the novel. It should be novel in its approach. Next is the Nuns. U is the utility. Utility means either commercial utility or the social impact. Suppose I'm inventing some mask for the corona and I'm using it and I'm patenting it and I'm doing this. So it has some commercial importance because it is giving protection against the COVID-19. So NUNS, the another U is very, very important, that without commercial importance or without scientific benefit or society benefit, your invention or your innovation has no importance. Now, third one is the O, the obvious non-obviousness. Now you can say, what is the non-obviousness? Most of the things which is the commonly present in the public domain. Okay, so if it is the public domain, you can say it is the obvious. Everybody knows. Suppose that I am telling that birds are flying and the fish are swimming. You will tell it is obvious. What is new in that? But when I will say no, fish are flying and the birds are swimming in water, beneath the water, then you can say it is a non-obvious because nobody has expected this. The man can fly with wings. We can understand with various machines it can be done, but when actually he will fly like birds, it will be non-obvious. So you understand the difference between obvious. Obvious means routinely, which is known to everybody. It is already in the public domain. So what new I am adding to that? So non-obviousness, like the people or the animals or the creatures from other planets, they are not visiting to the earth routinely. Means they are not visiting us on Diwali or the New Year. They are not greeting us. So it is the non-obviousness thing. But when you seen in the Jadoo, Koi Mil Gaya, the Jadoo came from other planet and he recognized the Om voice and he came. So the visiting the aliens from other planet and coming to Earth, it is a non-obviousness because it is generally never happened. Okay, so in that way, so overall, I mean to say that whatever your discovery is there, whether it is the inventive way or the innovative way, it should be eye-opener. Eye-opener means, oh, we never imagined this or we never thought it. If somebody is seeing your discovery, he should first tell, yo, it is non-obviousness. Non-obvious means I never thought or we never imagined this and he did it. So in that way. So now you understand that now in ATM, in the lockdown or the digital that monetization, okay, when all ATMs are lost, somebody thought for the Google Pay, Paytm. Earlier, we were relying on the banks only. So such type of things are, you can say, non-obviousness, thinking beyond their circle, thinking out of box. It's very important. Then only we can say, oh, it was never imagined, but it has come. So non-obviousness is very, very important thing because novelty, you can add it. Suppose you can see in most of the drugs, penicillin, the new versions are coming, like the mobile. They are having 32 GB. You can say it is 64 GB and you can add some application and you can say it is a novelty. So novelty can be added. The some improvement version functions can be added. When obviousness means directly it is the next generation, as I gave you the example of the desktop and the laptop. Nobody has thought that the desktop can be carried away. But when the laptop came, now we can see it's obvious. Laptop can, tomorrow the PAN tap and other things are also there. So nobody can carry. And second thing is the last, very, very important, is statutory, means the legal framework. Legal framework, what is you are discovering, inventive or innovative way, it should be in a legal frame. Tomorrow you can say that I developed one website which will hack all the good website. It is not allowed. Tomorrow you will tell I will prepare some bomb which can kill people. So it is not acceptable in the society. Copyright, plagiarized, or any malpractices. Suppose you can develop some operation theater, some machineries, and he will do automatic operation or can kill somebody. So such type you have seen in the robot movie, that how the robot's work can be taken out in a positive way, and another way also. So post interval session, you have seen that key or that robot was drastically changed. So such type of activities are not, you cannot claim for that. Okay, even if some surgery procedure you invented, but with the help of, in the absence of doctor, you cannot implement it. Okay, so doctors or the surgeon is always needed. You cannot rely on the machine 100%. So statutory means the legal framework. So none's rule always follow. If you are filing anything before the community, you should ask whether it is following none's rule or not. Now coming, there are the all 9 types of the intellectual property right. First is the patent. The patent is mostly related with the science, engineering, medical, and the applied fields, because it comes the 3 things. The one, the process, product, and the prototype. Now I will go one by one. So we have seen the invention, bulb, telephone, wheel, computer, these are the invention. And when it will converted to the modified form, it becomes the innovation. Now patent. Patent, we can think for the product, process, or the prototype. The fan is moving above us. He is a product. So I am just placing that this is a fan. It is having, instead of 3, it is having 6 pan. Because I was not showing whether the 6 pan is used. But okay, I can put a prototype. The speed with which the fan is moving. Suppose this is moving with 2000 RPM. I will improve it with the 3000 RPM. So if you bring some changes like 2000 to 3000, it will be the process. It will be the process improvement in the process. So as a process, as a technology, you can add it. And the product means, if this is a fan, everybody is knowing that the fan is having 3-4 fans. You can do something. So that can be a product. And the prototype means you are not sure whether this prototype is exact, but tentative model can be accepted. Ladder, like I told you that 6 fans are there. I'm not sure which is 6 are needed, but as a prototype, I can keep it. Later, as a market requirement, if I can understand, 3 fans are sufficient, so no need for 6 fans. But at least such raw prototype can be go in the market. So patent is a legal protection which gives an inventor the right to exclude others from performing certain activities in the country of issuance, sanction monopoly for the set of number of years in the exchange. And again, I'm telling you that all the IPR there belongs to the geographical area. Okay, there is no such word like the global patent. If you are applying in the India, this patent is valid for the India only. If you are applied to the US, UK, or India, that IPR will be valid only for that geographical barrier. So that is it is having the territorial rights. That's why we are calling it as sometimes the IPR, they are having the territorial rights. So patent, I gave you the example that the process, product, and the prototype. In this way, you can file it a patent. Now we will just see the history of the patent very early. That is in 1474, the Venetian patent law. The Galileo applied for a patent in 1593 for his invention of a pump. Then in 1624, UK patent in the parliament, that the royal the prerogative, they have applied it. Then in 1790, the US patent, the Samuel Hopkins of Philadelphia, he received first US patent. Then in 1970, some amendment was done. In 1957, the first Indian copyright and all these laws were introduced. In 1970, the Indian Patent Act came into the effect. And now the India, after, you can understand, after 1995, the Manmohan Singh, the Narasimha government, the globalization started, and India joined the hands with the World Trade Organization and the TRIPS agreement. And because of that, many multilateral agreements were signed, and all this patent and the IPR themes comes in a global way. So immediately we will come to know that Haldi patent, Neem patent, the US file, and immediately we stopped later. So after 1995, the globalization, and we could understand that how the world is moving. So we are keeping track on every the product, whichever is thing. So nowadays everything is transparent. If it is your genuine discovery, you can claim it. But if somebody is taken, you can claim it also. There are the different types of the procedures. So patent, you can call it. It is what is a patent? Again, it is the right of that inventor, that whatever he is putting or what is he is giving to the society in terms of product, in terms of process. Okay, he can license. Once he got the patent, he can give as a license to another company also. It can be same like the revenue generation. Okay, so that's why in the scientific field, the patent is the most important form of IPR, and it is taking more time also. 3 to 5 years it is taking for patent grant. But today, if you are filing the patent, it will be valid from that day. Tomorrow, if somebody has taken your concept and put it, so you can give him the challenge that, day before yesterday, I filed this patent, so it will be under my name only. So it doesn't matter when it will be get granted, as long as today you filed it, you secured it, as you protected your home with the lock. So today, if you have some good concept and you applied for the patent, you get protected. So nobody can take that idea, means until and unless then the journey will go on for 3 to 5 years. That is no doubt. But nobody can work or file it on the same model, because whenever he applied for that, so your first patent 1 day before filing will be come into the software and will tell you that the similar domain was already exist. So that is so protection against the imitator. So if you have any good or the innovative idea, file it. Then it will next proceed. There are the 3 stages in the patent filing. First is the filing, second is the publication, and third one is the granting. Granting is the last and the tedious, because after publication you will get many challenges. Like in court, you have seen that there's a public prosecutor and the opponent, or the lawyers are there. They are putting some claims and you have to justify their claims. So whenever you will put your claim, my baby is good or my product is very good, the opponents will tell how you can say that such type of product is already exist, or such type of functions you are saying it is already there. So whatever the claims they will put it, you have to justify that, you have to nullify that. So if you nullify it, then your claim will be sustained. So it is the same like that. Whatever you have seen in the Supreme Court or wherever you have seen that, you have to fight for your claim and you have to justify it in a proper way. Then once you clarified all their doubts and you come out with all that, your patent will be granted. So what can be patented? I already existed that the nonce rule. First thing, it should not be previously known to others. It should not be in a public domain. Because if you put something like I already told you that I am having the 4-wheeler. So everybody knows that car generally runs with the 4-wheeler. You are adding something new, you prove it by how this. So novel means it should not be previously known or used by others. Usefulness, it should have tangible results, concrete results to the community, to the society. Non-obviousness, I gave the example of that judge or something, non-obvious things. And statutory, the legal framework. You should not demolish, you should not crack, or you should not destroy the legal framework, which should be whatever you are using. You cannot use some software which can do the piracy or some movie or something like that, because indirectly you are affecting some other industry and their revenue. So obviously they people will oppose. So unethical or illegal practices cannot be patented or cannot be comes under the IPR. What you cannot patent it is the law of nature, like the Newton's first law or the first law of thermodynamics or the law of nature, scientific principle, gravitational motion. So such type of things are the primary discoveries which have been done. You cannot challenge to it. You create your own ABCD and you write it. So patent is always new thing as per the inventive way, or you can change it as the innovative way also. So another important thing is the copyright. That is the first we have seen about the IPR. I will first just cover all the 9 types of IPR, and we will come to then the question answer session also. So copyright is the creative mind, that is artistic mind, literature mind. So in that copyright, you can see that literary includes the books, essays, compilations, computer program. All these can come under the literary, including the softwares. The artistic is like the drawing, painting, logo, map, chart, photograph. That comes under the artistic way. The cinematographic, you prepared or developed some documentary, sound recording, you are singing the song in your own voice. That cinematograph films that you can copyright it. Musical notations, You have some rag, you have some bandish or anything else. So musical concepts, notations, you can do it. Sound recordings, the compact disc that will, or drama, you have some screenplay, you have developed some drama or some nukkad activity, anything. And if you want it that it is a unique one and nobody should take it, you can copyright it. The one more important thing that the patent, the life of one patent is the 20 years. Till 20 years means today if you file, and it will take 4 or 5 years for the granted, but from the date of the filing to the next 20 year it will be valid if it is get granted. So if get rejected, then forget about it. But if your patent is get granted, then from the date of filing it will remain valid to 20 years. After 20 years it will come to the public domain, then it will not be your property. But copyright protection is lifelong. Suppose you wrote some poems, so you wrote some books, so that book will remain throughout your life and even after your life also. Like Gitanjali, Munshi Premchand's Godan, it is their creation. Nobody can claim it. Okay, so beyond your life also it will come. But patent is not like that. If I am holding one patent, it will be valid till 20 years only. So copyright is the most simple form. You just publish a book, you will get ISBN number and it will be your lifelong. Even after your death also, it will be remain to your knowledge only. Now trademark. Now copyright and the patent is related with the academics field. Now we are coming to the industrial portion. The industrial portion we need trademark. I am opening suppose one company and I want to give some logo, some symbol to my company. So you can see the Sony, Carlsberg, Coca-Cola, Intel, Microsoft, Canon, Mercedes-Benz. All these are the trademarks. Okay. Snoopy, you can use a word. Dior as a name. Three-dimensional designs. Coca-Cola as a combination of word and these symbols. Or the restaurant, this is the abbreviation. Or you can see that the reverse words also you can use. The name of orange or the colors you can also take. Letter of abbreviations like LIC, BMW. Okay. The drawing also you can take. The music or the fragrance you can also use as a trademark. And the numeric, Lahar 7-Up, Lahar Pepsi, Thumbs Up. So you can understand that the trademark is nothing but the symbol, like McDonald's, M, KFC. They are using the symbol or the figure of their owner. So you can use it as long as it is the commercial product and you want to brand it. Only thing, this type of designs or this type of symbols, names, awards should not be repetitive. So there is a one repository is there. You have to just check whatever the trademark you want to use it for your company. It should not be repeated one and it should not be matched with somebody else. Sometimes it happens. So now they are showing the differences, like their angle or their name is different and ours is different. Now trademark, it is for the protection right. It is again the territorial right. So if India it is the Lahar 7-Up, so it doesn't mean that all over world they should use it. The outside India they can use it the Thumbs Up or the Lahar 7-Up like that, the images. This means that they must be registered separately in each country. Unless a given trademark is protected in a specific country, it cannot be freely used by the third party. Okay. So almost all countries in the world maintain a register of a trademark at the appropriate trademark office. So trademark is very genuine concept. You are opening your company, you decide your own design and you go it. Now the trade secret. Now trade secret, suppose you are producing some perishable product. Suppose you are producing some badam doodh, or suppose you are producing some chole bhature, and you understand that whatever the masala, spices you are adding into that chole bhature, it should not be taken up. That formula should not be copied by somebody else. So that trade secret, you can use it. Any formula, practice, or suppose any material you are burning, you are boiling it at particular temperature. So any preparation process, practice, pattern, compilation, information that can be comes under the trade secret. So that because wrapper now the biscuit, suppose all biscuits they are different in the taste. Why? Because they have IPR it. We can use the word IPR. It means they protected their trade secret in that word. Like the MDH masala and all these things are there. They are doing this trade secret so that their formula cannot be taken over. Now the trade dress. Trade dress is the external appearance, outermost covering. Sometimes most of the time the things are common, but you want opening one company, so you need a trade dress. Like the Agrawal Movers and Packers. It is a simple mover and packers company. They are just taking your luggage and putting it to somewhere else. But whatever the wrappings they are doing to your luggage and all this, they are using Agrawal brand and all this. So why that? Because they have nothing to do. It is simply cargo or it is simply the transportation company, but they are using their logo. So it is a trade dress. For example, Parle-G, you can see that the unique Parle-G or the Nirma, you can see one girl, you can find it over. So on the trade dress, they are putting some trade dress so that no one should copy. Otherwise, what will happen? They can do this, the cargo or the shipment type of business, but they should not use, because if you are more in a market more than 20-30 years and people are relying on you that this person or the company shipment company belongs to this person is very reliable, then you have to use such trade dress so that no one can take out your this one. So trade dress is nothing but the outermost covering of this. So trade secret, I told you that ki masala, Maggi, fried chicken and all this, they are doing. And the trade dress means the outermost covering, which is giving the attractiveness to that one. Now the industrial design. So we have seen that the trade secret means the logo, trade secret means the formula, and the trade dress means the outermost covering. Now it comes to important part, that is the industrial design. You can see there are the many types of the shoes. They are having the common platform. But even in that shoes, they are placing some more design, because the design is related with the external look. The external look will attract the customers. So you can see many PC, but their PC, their backside end or their screen, they're having little bit difference. So it is related with the industrial part. So industries, they are making the design to get attraction, to get more attention from the customers. So design is also important part, but it is related only with the external appearance to that. But you can say that how the industrial design can be separated from the covering, because in the design there are the other product utilities also there, but covering is only the trade dress, which is just the protective part. That is the thing is there. So design is, you can see many designs here. Calculator, mobiles, or the pen drive, they are having the different shapes and the different size. Why? It comes under the industrial designs. The important part is the next one. We have seen the patent first, then the copyright, then the trademark, third one, then we have seen the trade secret, then we have seen the trade dress, and next one we have seen the trade design, industrial design. The next part is the geographical indication. It doesn't belongs to any individual. Geographical indication, like we are staying in the India, so we know the beauty or the uniqueness of any particular state or the particular area. So geographical indications like the Bengali Rasgulla, Kashmiri apple, Nagpur oranges, Agre ka petha, Mysore pak, Kanjipuram sari, Banarasi shalu, Lucknowi chicken, Maharashtrian paithani, the Patan ka patola, whatever you can call it as, okay, or Lonavala chikki also you can call it. So geographical indication, that state authority you should claim. Okay, nowadays you understand that the Kolkata, Bengal and the Orissa, they were fighting for the Rasgulla. And result was gone from the Kolkata side, means West Bengal side. So if you understand that any particular importance, Madhubani painting or anything is there, Tanjavur painting. So if some such type of uniqueness or some artistic creation or some perishable product is there in your area, but you cannot claim, but the state government, they should take the lead and they can go for the geographical indications. The geographical indications is also the new things are coming, and I can say in the last 2 years more than the 53 products they get filed by this way. Now SICLD, it is related with the engineering people, the semiconductor integrated conductor layout design. If you open any transistor or the radio, you can find there the circuit design. But all circuit designs, they can also have the different design or the different portals. So this semiconductor insulating material, circuit diagrams, designs, they can also be patented, and for that there is a separate categories given, that is the SICLD, that is the electronic engineers, they can file it, that is the semiconductor integrated conductor layout designs. Now we have seen that another one is on the plant varieties also. I think this slide is missed. Plant varieties. Plant varieties generally include most of the time the agriculture to any new variety. Suppose you are going to the Himalayan side or the Rishikesh side, then you will come to understand that there are the very rare or endangered species are there. Endangered species means if we will not preserve them, they will be gone away. So such type of endangered species, can also be registered under the Plant Varieties Act. So it is another one type of the IPR is there where the plant varieties can be registered. Or suppose you are producing some hybrid. Hybrid means the farmers and they come to know some hybridization technique and they come to understand that any raw or any type of the hybrid variety of any plant that nobody has noticed till now. So they can also register on the plant varieties, and for farmer there is no fee is taken. If any institute or any individual is applying, there is a fee, but for farmers it is a totally new one. So IPR at a glance, I'm just taking the few parts to here. Now you can say that the main offices in the India, more you want to know about the IPR, you simply no need to go at the India level. You have to go on the IP India nic.in. Once you go, there are the different portals are there for patent, copyright, industrial trade design, trade dress, trade secret, geographical indications, plant varieties, and all these things. All the 9 types of the IPRs are there. The different sections are there. No need to go, no need to get disturbed or no need to get confused. As far as the world is there, the WIPO is there, World Intellectual Property Organization, WIPO, WIPO. And as far as India is concerned, there is a IPO, Indian Patent Office. So IP India office, you visit it and you can register yourself and you can apply for all the forms are there, all informations are there. Generally for all IP offices, they have kept the 4 regions, Eastern, Western, Southern and the Northern. So Delhi, Mumbai, Kolkata and the Chennai, these are the main offices always there, but they are having the main centers also. Like for the circuit, we will come to the patent office, all 4 regions, the Mumbai, Chennai, Delhi, but Kolkata is there, the main office for this. So Kolkata is there for patent, for copyright, Delhi is the main office is there. Design wing, they are having the Kolkata as a main headquarter. Trademark registry, they have added one more, Ahmedabad for trademark. Suppose you are opening any company and you want trademark, so you can go through the Ahmedabad. Geographical indication is the Chennai, but the state government has to take the claim because it is not our property. If any or Nagpuri oranges is there, so orange belongs to the Nagpur. So Maharashtra government should take a claim in that way. Now the SICLDR, that electronic engineer circuit integrated layout designs, that is the Delhi is the office. So where it is protected, I'm just quick in the glass. I will go some other thing. What are the other benefits of this? So you can understand that now till now you are coming to know the World IP Days. So World IP Days, you understand that the 26th April is the World IP Day. It is celebrated as the World Intellectual Property Days. And in 2000, the WIPO, the World Intellectual Property Rights Organization, they have organized one event to raise the awareness of how the patent, copyright, trademark, and design impact on daily life. So 26 April, you can mark it, which is coming after 1 or 2 months. So why 26 April? Because in 1970, first time the India joined hands with the WIPO. I told you that in 1970, first time all the IPR law came into existence. Then again, it comes to 2002. Their amendment in the laws was happened. So keep eye on the track on the April 26. They are organizing any theme. Suppose in 2020, April 26, the theme was Innovate for a Green Future. So every year they are keeping one new themes. So WIPO, World Intellectual Property Organization, and IP means the Indian Patent Office. So I don't know what is the new theme for this year, but it will come to know that if you go on the WIPO site. So please join this April 26 because they are conducting the quizzes. Your context, your idea, your any imaginary things, you can put it there. There are the 7 days. Last time 20th April to 26th April, that 6 days, 7 days that program was lasted. So 7 days program was there and there was a various creativity contest. So you can take part into that. Again, intellectual property is nothing but the giving safety or the protection to your intellectual mind, intellectual outcomes. So the same like the here is transferring their asset to the newcomer. You can also transfer your IP rights to your newcomer or to your son or to your family. So try to focus more on in today's world we are earning or we are focusing morely on the tangible assets like the car, 4-wheelers, bungalow and all this. But try to earn intellectual property, these intangible assets also. So give more creativity to your minds. I already explained the patent, copyright, industrial, all these 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 types of the IPRs I explained here. Plant varieties also giving protection to the farmer. If you came across with any of the tribal plant or the tribal area, any plant varieties, and if it is having that non-stool property and it is not existed in the taxonomy, you can register it. IPR is very, very important because it is contributing to the GDP. So I will not going more into the commercial part. More IPR, the China is more dominating nowadays. So if you want to be there, you can understand almost 30 to 45% of the GDP is depend upon the IPR commercialization. Only IPR granting is not important. Your innovation, some company should come forward and should take it. It's not like that I wrote one book and I kept it, I published it. The viewers, authors should read it. So when your IPR will be commercialized in a proper way, company will come forward, then only the GDP will be improved. So MOUs we are signing, but we don't need MOUs. We want functional MOU. We want something to be on the reality, something to be achievable. So that's what I'm telling you. The commercial IPR is very important. Okay. So I'm using this word. Again, this is I shall not go more detail in that the commerce part, but you can understand indirectly the intellectual properties is correlation directly proportional to your growth, your GDP. More the intellectual property outcomes, more commercialization, more strong your company is there. That IP important I explained. Third party violation can be prevented. Third party violation can be avoided. And there is a many scope. Those who have done the degree program, if students are listening, they can make their career as a patent analyst, patent searcher. Only thing, after your basic degree, you have to do 1 year course, but that course also from the reputed institution, not as a correspondence or whatever you are getting Facebook remark. You first see whatever the IPR degree program you are taking, it should be registered or affiliated by IPO or other IPO or any other good regulated agency only. Otherwise, you will just do 2 months course and you will think that I am a good IP expert. It is not like that. Practice is more important and number of experience, because IP is a totally different field. So you cannot say I am 25 and I am 30, I am a good IPR expert. Even 50, 60 years also, the people, they are not. It is just like the Sensex. Nobody can understand the stock exchange, but it is not a tricky like a stock exchange. You have to be more thorough. You have to be more experienced in that IP. So IP paralegal, patent docketing, patent proofreader, the time, I don't know it is there or not. So I have to summarize trademark attorney. So any graduates, they can do it, but do at least the fundamental course of 1 or 2 years or understand the basics by visiting the IP website and then claim yourself as a trademark attorney. It is the same like the doctor. Thus, you got the degree, you cannot be a doctor. More patient you handle, more your practice, number of years, then only you will be the expert in that field. Okay, so it is a practice like that. You have to be dedicatedly and with the proper commitment. You have to go ahead. The patent agents is there for one patent filing, almost 1 lakh rupees commercial expenses coming. So you can understand that at least in 1 year, at least 10 cases you are handling 10 lakhs. Okay, but more important is that how you crack it, how you grant it. So technically, if whoever is applying is not strong and the agent is also not strong, so it is a synchronized way. Okay, you should know, your technical person should show technically possibly, and patent agent should present it in a better way. So it depends on the both. Only I hired a good patent, but my innovation is zero, then it has of no use. But I know many things, but if my patent agent is not possible to elaborate it so it is also useless. So it should go in a rhythmic way, in a synchronized way. So many software engineers, at least in the science field, there is a sky is the limit, and many software engineers, they are taking a lead role. So job titles are all these, those who want to make a career as a patent searcher, IPR paralegal, docketing, proofreader, patent agent. So it is a tough task, but it is not a difficult one. It is not an impossible thing. You have to be very thorough, because any mistakes if you are doing, so better write less, but whatever you write, it is a perfect. It's not like a writing paper, publication, book. You will write anything. Anything you write it will be come under the claim. If you have a speed of 100, you write 100 only. If you write 100 to 150, the front person will ask how you wrote 150. So be very specific in patent drafting, patent writing, and if any guidance you needed, approach to CR4D. My name is Dr. Vijay, Deputy Director here, more than working almost 2.5 years and more here. So any doubts, any queries, you can pin drop, you can email me, WhatsApp me. All I welcome you anytime at CR4D. PG diploma course is there 1 year, but do from the reputed organizations. And future market is obviously there is a very good. In last year, India 50,000 patents they filed, 3.5 lakh trademark applications are there. So as we see the intellectual property market, it is almost 12 to 18%, and it is gradually growing. Now the startup ecosystem is also growing in the India, make in India, made in India. So people are also taking the claim. Now in the Times of India, one news came that the contribution of NRIs in filing the patent is more. So we have to increase it from the India point of view. Being as a citizen of India, we should take more part into that. And still more manufacturing units and for research ecosystem, the favorable atmosphere is growing. So I hope there is a bright future for the IP in the coming days. So I think that I shall conclude here, and I hand over to you, Madam Madhvi, or the organizers of this.
Hello, sir. Yes,
Yes.
sir. Sir, it was a very good session. You almost covered everything about intellectual property rights, starting from patent, protection of all rights, trademark, and then trademark secrets, trademark dress. So I think all PhD students, ongoing scholars, and who are doing masters would means they got proper information about intellectual property rights. And apart from that, sir, we have a question that it is always necessary to hire a patent person or a patent agent.
No, it is not required, but sometimes I suggest you can also do it by your own, but for that you must understand all the basics of the IPN. Because when you are hiring a patent agent, he will go through the none step. Okay, because I already told you that you have to do the litmus test. Whatever you are filing, it is satisfying none test, novelty, non-obviousness, utility. If you cannot go and you can do it, you can go to the IP site and you can register it and you can do it. But at least I think that go with a one experienced person. If you are totally new, don't take the risk. Because it is not like the paper. Once they reject it, you will get demoralized then again. So the patent agent and experienced patent agent, I'm telling you, if you are hiring any patent agent, you first ask one question: how many patents he granted or how many patents he is handling. So at least you will come to know that the idea of his track, his professionalism. Okay. Even if he say, no, I am very new, so don't go that. Even if he is having 20, 30 years, so at least he has gone through all the drawbacks, pros, cons. So obviously his experience will be beneficial for you. It is not IP is not cup of everybody's tea. That should be clear. Yes.
Yes, sir. So then how can students get information that which patent agent should be hired, or from where this information can be got that patent agents are available where? Means you have given the names of the offices where it can be registered. But patent agents, how can they find out on? Are they available on?
So I'm telling you, there is no site. There is a DPIIT. There is a DPIIT Department of Promotion of Industry Promotion site is there. I'm sharing with you. I hope you are able to see this. Hello.
Yes, sir.
So if you go on the IP, there is a list of facilitators for patent and design. Okay. So if you see the DPIIT, the Department of Industrial Policy and Promotion. So this DPIIT is facilitating the name of the patent agent. So at least till knowledge, whatever there, irrespective of this, overall India, there are this list is there. So you can see their contact number, their email IDs are there, or you can go to their websites also. So you can rely on this because that government has authorized these agents. So rather than going through the Facebook or some advertisement, you always check on Google the DPIT facilitator, IP facilitator, or the patent attorney DPIT. Because in the patent, the Department of Industry Policy Promotion is taking up dominant role, and it is checking the integrity of this patent agent.
Okay, sir. So 1 lakh rupees is the minimal charges to be for patent filing. Apart from that, students need to give this money to patent agent also.
If you are doing at the self level, so you can understand 30,000-40,000. But when it comes to institution level, suppose like Parul University, in Parul University we are having flexible IPR policy. All the expense will be taken care by the management. Okay. So there are the 3 process, like the first patent application, the grant filing, then granting. So I am telling overall expense. Okay. It will first time 18,000 you have to pay. Okay. So 1 lakh it is coming, but it is in the 4 to 5 years. At a time you don't need to pay it. But you must understand that that patent, if you have the royalty, if your innovation is innovative and they are having some commercial potential, so that 1 lakh rupees is not a big one, as long as it is a patentable. In CR4D, we will share.
Thank you very much for solving all the questions.
Yes. I want to ask how many audience.
Thank you very much for.
How many people are there?
Almost 50 students.
Okay.
So, almost 50 to 55 students for the because they are from masters and sir PhD. So not much, but those who are into PhD and they have logged in, sir.
No issue, madam. Thank you.
I will forward the mail.
Please.
Yes, sir.
I hope my email and the communication contact number is there. So please approach me anytime. Okay. Yes. Thank you.
Yes, sir. Thank you, sir.